So it's a real delight to be here. And before I start I just want to have a little sense, because I've got some ideas, but the thing that I worry about when I do PowerPoints and get everything is people get all into, oh, she's got all these ideas of what she's going to do, and she's locked into that. And I really want to make this something that's going to be useful for you all, because you've taken time out to come spend time here. So how many folks actually practice with the Clean Water Act on a regular basis? Couple are just here for fun and kind of background. Well, that's good, because I've got some stuff that I can kind of do some real basic background and hopefully get you up to speed, because even if this is not something you do every day, this is the fact that there's been some real big changes to this aspect of national permitting program is something that hopefully will be of interest to you. So, especially now that I know that I've got some folks to whom this whole area is new, I will spend a bit of time making sure that we understand the Clean Water Act. And then I'm going to talk about what is this thing called mitigation, and then this brand new rule that came out in April. I'm also going to close with an impact on something that I've been studying, continue to study with respect to the Corps and the people who interact with the Corps, who the Corps labels its customers. And I'm going to be sure to leave some time so that we can really have some interactive questions and answer sessions. So as I begin, let me very much thank the fund that brought me here, the Stegner Center and the university, for letting me spend this time with you. And let me also say, if at any time, I don't reserve questions. If you want to bring something up or you want to stop and go a slightly different direction for a few minutes, please interrupt. I'm not wed to my ideas of how to spend this time. They're just my ideas of some of the things that I'd like to share with you. So we have a framework that protects our nation's waters that's actually been in place since the 1800s. The Rivers and Harbors, there were actually a number of Rivers and Harbors Acts in the 1800s. The one that's still in force today was enacted in 1899. And it provides some very specific regulations when you're going to be impeding navigable waters or discharging into navigable waters as defined under that statute. But it turns out that, as we knew through the 1900s, and especially as we were birthing all the environmental laws that we have, that we figured out that the Clean Water Act, that the Rivers and Harbors Act and existing laws that states had, and the previous laws, Federal Water Pollution Control Act that was in place, wasn't doing as good a job as it should have been. There were like rivers on fire. There was all sorts of pollution going on. So we enacted that through our congressional representatives, the Clean Water Act in 1972. It wasn't actually called the Clean Water Act in 1972. It was called the Federal Water Pollution Control Act. We gave it that nickname actually in its next reauthorization. And as part of that, what Congress put together is this lovely language, which is the primary language that we use to regulate putting things into waters. There's other sections that we regulate discharge that comes through pipes, through the National Pollution Discharge Elimination System, but this is the stuff that regulates wetlands and other types of discharges into water. This allows the Secretary to issue permits after notice and opportunity for public hearings for the discharge or dredged or fill material into navigable waters at specified disposal sites. It's kind of cool that Congress did this because it gives me a lot to write about. And it gives people who work in this area, depending on, doesn't matter which side, a lot to work on, because it's not the clearest language. And I'm confident if we all sat down for the afternoon and said, hey, let's figure out how to regulate wetlands and other waters, this probably wouldn't be the language we'd all agree on, regardless of our position, because this just was not as clear. When you go back in the legislative history, which I actually was fortunate enough to have the opportunity to do when I co-authored a brief in the Rapanos case for members of Congress with Bob Adler and Amy Wildermuth at the university here, I really got to spend a lot of time figuring out Congress did have protecting wetlands and other waters in mind. They understood, certainly at that point, what was going on with wetland ecosystems, and they really did want to spend some time, invest in the nation's protecting them. But it really has caused us to have a regulatory process that implements how we protect the nation's wetlands. And I say wetlands, and I do that because it's what I work on all the time, but I just want to make sure that it covers all, we understand it covers all navigable waters, including tributaries, including dry washes, including areas and that we're not quite sure exactly where the ends are, and that's a whole nother CLE, what's happening after the fight that's happening about navigable waters and the 414 decision that came out of the Supreme Court in 2006, the Carabel-Rapanos decision. Pardon me?
Vernal pools.
Ah, see, it depends. The Solid Waste Agency case in 2001 said that we couldn't use migratory birds, but if you can find another connection, they may be in, and it actually depends on the district, and it depends on what people are using for tests. And so some conclude that they're out. Some conclude that, especially after Rapanos, and you look at the test that was developed by Justice Kennedy in terms of significant nexus, there may be a way to bring them in. And so that's a fight. The A3 waters is a fight that we haven't yet fully explored because we're still dealing with the other Rapanos decision. Good question. Right on the cutting edge of what's happening. That's once again kind of why it's fun to be an academic here, because who knows? When we think, this is like the example of what not to do with a PowerPoint slide. I do know this is a bad PowerPoint slide, but I just want to. I was going to just have what the goal of the whole Clean Water Act was, and then I wanted to make sure that you understood that Congress actually listed some sub goals. When you're in this line of work, you are constantly hearing, you've got it memorized, you say it in your sleep, why Congress enacted this: to restore and maintain the chemical, physical, and biological integrity of the nation's waters. Whenever we're looking at what's happening with the Clean Water Act, we go back to what Congress had in mind. The goal, all of the case law does that, all of the regulatory proposals do that. They're constantly referring to chemical, physical, and biological integrity of the nation's waters. In terms of how to achieve that, Congress even went really specific and said, okay, these broad goals should protect and propagate fish, shellfish, and wildlife, should protect recreation in and on the water, eliminate discharge of toxic pollutants and toxic amounts, and control non-point source pollution. So there's a lot that Congress was trying to achieve through this law, and but actually making it happen has been fascinating. There are two, and I don't have a slide about this, and I should, but there are two primary agencies that regulate under the federal Clean Water Act. The EPA, this brand new thing in the 70s that was created, the Environmental Protection Agency, does most of the Clean Water Act and actually has a role in 404. But there was a huge fight about, should we give this brand new people something that they might not know about, or should we keep the Army Corps of Engineers, who since the 1800s have been regulating, as I said, under the Rivers and Harbors Act, what navigable waters are. And so the ultimate compromise was, well, we'll let them do it together. And so the Corps of Engineers has the primary day-to-day authority for issuing permits. But there's a veto power and an issuing of certain types of regulations that apply to every permit, and an ability to elevate if they're mad about what a particular district did that the EPA has, which for a while at the very beginning was very tense. Then for a while got quiescent, and now after Solid Waste Agency, in particular Rapanos, EPA is in there really looking closely at everything, and in some areas there's a lot of tension. But the regulatory program goals for the Army Corps of Engineers are very interesting to me as a scholar. They say these are our goals, and they're very clear about saying there's no meaning to the order in which they're listed, and we are doing three things. We're providing strong protections of the nation's aquatic environment, including wetlands. We're enhancing efficiency of Corps administration of its regulatory program. There are many people who do this day to day who laugh at that, but they're trying. And then to ensure that the Corps provides the regulated public with fair and reasonable decisions. So that's a lot to try and do. And it's interesting that they've got that only a third of it is about what seems to be what Congress had in mind when they put the Clean Water Act in place. The customer satisfaction survey, I'm going to actually talk a bunch more about that at the end, so I'm not going to take you to that right now. So we've got this Corps. The Corps of Engineers has a big regulatory program, and they have 1,200 people around the nation who actually implement the regulatory program on a day-to-day basis. It's a very decentralized system. It's been interesting to me, living in South Carolina, we actually have one district and one division that we answer to. So following things in my own home areas is more interesting. There are other states, like this one, that have multiple districts and divisions to answer to, and it can become very interesting because there are 1,200 people who run this. The idea behind it is waters are different in South Carolina than they are when I was born in Massachusetts, than they are where I got to work a lot when I was in private practice in Alaska, than they are here in Utah. And sure, there should be expertise and some decisions based on what waters are actually there. On the other hand, the thing that's always fascinating to me is we get 1,200 people. Guess how many people actually are assigned in Corps headquarters to provide guidance and operate things out of Corps headquarters of these 1,200 people? How many FTEs does the federal government give to Corps headquarters for regulatory? Any guesses? No, that would be good. No. There are actually 6 FTEs. Currently, there are only 4 people who are employed. So it's very interesting because you try and figure out, so I told you that there are vetoes, there are abilities to elevate and get reviews of what the districts are, and then you kind of send that forward. And there's not all that many people to work on that.
They have 7 divisions.
I think they could even use more than 7. I think that I think that there should be a good number of people, because they also don't issue regulatory guidance letters or things that are more helpful on as regular basis as I think could make it easier for all the stakeholders to deal with things. But that's the way things are done, and I've opined on this routinely, and for some reason the past couple of years, even though I've written about it, they haven't added FTEs. So there are a whole bunch of stakeholders who fight about this on a regular basis. And I typically talk about, there's the permitted community, the regulated community. The Conservation Act community calls them the developers. But I had the pleasure of working for Hunt & Williams, and I had the pleasure of working for a couple other law firms. And so I do know that most of the people who are regulated try and do the right thing. And so they really are trying to just fit in. There are then the environmentalists who aren't one whole, cohesive whole. They have factions, and there's actually a group of themselves now that really want to be called the conservationists rather than environmentalists, because environmentalism has some connotations in certain parts of the country that some people want to divorce themselves from. They're the regulators, and those are the 3 people who are in it day to day. And then I've kind of added the public, and then I think, theoretically, when I'm really looking at this, I think that lawyers and consultants, on some levels, are their own stakeholders. Because they want to do for their clients or for whom they're representing the right thing. But there's also an interesting level of expertise that's developed as time goes on when you are a consultant or a lawyer in this area. And that's one of the things of figuring, the people who really start to figure out these new mitigation rules are going to be able to help people through the process, because it's a brand new, huge, complex layer that's been added onto the permitting process. So as I said, 404 says you have to get a permit before you can go forward and do something. In order to get a permit, you file a permit application. If you go on the Corps headquarters website, you actually find this permit application. I just went on this morning to confirm, because I always get nervous when I do this. And in fact, they do have this permit application on the Corps headquarters website, which expired, as you may not be able to see, in 2004. But they haven't updated it yet. So this is still the permit that you would use. You fill out this permit and you submit a whole bunch of attachments and a lot of information. It's not an easy process. I represented folks. It's not a non-burdensome process, but it's something that the agencies feel is important because it's what they believe that Congress directed them to do to maintain the chemical, physical, and biological integrity of the nation's waters. The Corps of Engineers actually regulates, as I said, Rivers and Harbors Act, and there's one other statute. They have one single set of regulations when you're going through permits. So that permit I just showed you a picture of, that's what they do for all their ones. Usually, people go in and they talk with the Corps before they submit a permit, especially an individual permit. Usually you have pre-application, I say sometimes, but it's more like usually. Once an application is submitted, the only timeline, the only actual deadline that's in regulations that they have to do something once the permit is issued is they have 15 days to determine whether the application is complete. And this is a bone of contention, is because sometimes applications are submitted without things they need, and then some people believe that some persons in some districts say that applications aren't complete to not start the clock ticking in terms of how many days it's taken to review a permit. But once the application is complete, a public notice and comment goes out. There's an option for a public hearing. Sometimes other statutes trigger the obligation, including NEPA. But if it's not triggered by another statute or other regulations, public hearings depends on the district whether or not you're going to have a public hearing. And then there's decision deadlines. But I'll show you some timelines in a minute. About 2/3 of the permits issued in less than 120 days. And the permits come out as applied for, very rare, with conditions, the usual play, or denied. That's also very rare. At the end of the day, if you don't like what you've been given, you can appeal through an internal administrative appeals process. That was started about a decade ago. It's actually not turned out to be as popular a process as people thought originally. And part of the reason of that is you go up through the appeals process, you go from the district, the decision you got from the district to the division, the appeals officer reviews it, and if they approve it, then it goes forward. If they don't, then they send it back. And apparently in many, many districts, even if it's sent back for further review, the majority find another way to reach the same decision is what I've been told is happening now. I actually haven't unpacked the data on. The data does show if you have an administrative appeal, if you initiate an administrative appeal and hire a lawyer, you have a significantly higher process if you've got a lawyer in the room with you of getting the appeal, being successful in your appeal. The Corps has been under the gun for a number of years, and so one of the things that Congress had them do a couple of years ago was start to really look at their statistics. Most permits are processed through the general permitting category. They actually do keep numbers updated. This is the most recent one, however, that they posted on their website. So I wanted to have this because this is most recently publicly available. The numbers really don't change all that much. So we've got a number of processes. We have somewhere over 80 and less than 90,000, and that's about where it stays. Only about 4,000 of those go through the detailed individual permitting process. The vast majority of them are general permits, and about the same numbers go through the individual permitting process are formally withdrawn, and a very, very small number are denied. So as part of this process of getting a permit, you often get permission to fill. And in getting permission to fill, you have to mitigate. And in fact, the person who taught me when I was studying at GW and taking one of my very first courses that I took in the GW LLM program, the person who taught me was Lance Wood, and he said the concept of mitigation is what saved the permitting program altogether, and without mitigation, it would no longer exist. People would have gotten rid of it, but the ability to actually mitigate and therefore continue to fill has been something that has allowed people to not overly revolt. Mitigation comes from 404B1, which is one of the things that EPA was given responsibility for by Congress. Appropriate and practicable mitigation is a precondition to being allowed to discharge. And it's in these guidelines that they came up with this concept, which is just always fascinating to me, that we call it mitigation, and then what we do is we say we're going to sequence it. And the biggest thing we're supposed to do is first we're supposed to avoid which I don't see how that's mitigating. I think if we're avoiding, that's before you mitigate. And then if we can't, whatever we can't avoid, that test is to the maximum extent practicable, then we minimize. And to the extent we can't minimize, then and only then are we supposed to compensate. And compensation, according to the 404B1, can include restoration, creation, enhancement, and sometimes preservation. So these regulations came out by EPA, which provided some guidance, but really no idea of how to make this happen on the ground. So there were some continuing fights. And then EPA and the Corps issued a Memorandum of Agreement that helped to define further how this compensatory mitigation was supposed to happen. The goal is not to replace an acre with an acre. The goal is to look at what is this wetland or other water doing, figure out its functions, figure out its values. We're now calling them services, actually, under the new rule. And the goal is to at least replace one-to-one. The preference in the 1990 Memorandum of Agreement, which is still in place, mostly, although some of it was gotten rid of by the new rules, is in-kind, on-site compensation, but that's a little changed up, and we're going to talk about that in a minute. And then restoration and enhancement is preferred over creation. That remains true. And the interesting thing is, after this process, the Corps often, as those of you who do this can tell, the Corps often looks at acres because they can't figure out functions and values as well, except in big, expensive projects. And then they say, look, we required 3.2 acres for 1 acre of fill, and we're actually generating wetlands functions and values in this nation. And so for a while, they were claiming that its regulatory program generated a net gain. But there was a lot of pushback. There were a lot of people who were like, we don't know what's happening. How are you testing its success? There were a lot of scientists who were going out and starting to study what was going on with these mitigation sites. And in fact, the Corps and EPA then decided, we need somebody to look at this. We're having a whole bunch of scientists do little things. We need National Academy of Sciences to issue a report. And I'm going to talk about that. And then there was a directive from Congress that led to this new rule, that's what we're going to be talking about. And the effective date of this new rule is now been a couple of months, and there is a lot of interesting things that are going to be happening in the next couple of years as this new rule goes into true implementation. But let's go back to the 2001 report. The 2001 report, the National Academy of Sciences said, you know what? When you actually look at what's happening, the concept of no net loss, which came from the senior Bush administration, and this administration has committed not only to no net loss, but to attempting to gain wetlands. That's not happening out there. We need to have a watershed approach, compliance. We're not testing it. It's not being attained. Support for people who are trying to figure out how to actually make this work in the field is not good enough. And by the way, people who are doing this professionally, the third parties, they might be doing a better job in a lot of cases. So this report came out. That same year, there was a study of in lieu fee mitigation. Sometimes you can't actually do mitigation on your site, and you might not be able to get credits in a mitigation bank, which we're going to talk about in a few minutes, but it's a compilation of an area that's providing functions and values that you can purchase credits in or create and then draw down credits if it's your own. The 2001 report said the in lieu fee program, where you can pay to have other good things happen, wasn't working. It said it was uncertain, but it really was looking at the fact that there was a lot of data out there that was showing that in lieu fee may have been abused. So we have these two 2001 decisions led to a national mitigation action plan. You can see the agencies down there. You got the Corps, you got NOAA, you got EPA, Interior. You got all these agencies that do wetlands work getting together and trying to figure out, okay, we know the mitigation system is broken. We know we can make it better. Let's figure out how to make it better. And then their work came to a screeching halt. Oh, wait. Mitigation banks, at the same time, while this was happening, were increasing. In part because the National Academy of Sciences says these mitigation banks, these places where people are creating areas that can be drawn down, are working really well. And so the numbers were going up and continue to go up, and the number of entrepreneurial banks was increasing, according to the data from the ELI, the Environmental Law Institute. But then the screeching halt came because the National Defense Authorization said, okay, enough with this mitigation action plan. We're going to require that regulations be issued establishing performance standards and criteria for the use consistent with Section 404 of on-site, off-site, and in-lieu fee mitigation and mitigation banking as compensation for lost wetlands functions and permits issued by the Corps. So this came out. Those of us who do wetlands kind of scratched our heads because it just suddenly came out. And so we went rushing off to do what I do on a regular basis, which is, so let's find legislative history. Let's kind of see, was there some sort of hearing? Who was there? There's no legislative history on this. You cannot think, it just kind of appeared out of whole cloth, and there's nothing to guide you other than that language that came out. Reliable sources, including one of my other former professors through the GWLLL program, Peggy Strand, who's a good friend and active in the ABA section and did a CLE for the ABA, Wetlands and Water Quality section on this, talks about the fact that one of the big major components of arguing and lobbying for this was the mitigation banking industry, whom she represents. So we've got this new rule, and so the Corps and EPA started saying, what do we have to now issue regulations. So they went in as part of figuring out what to do, and they looked at how mitigation is happening and really unpacked the data. So about a number of areas of restoring, meaning going in and enhancing and doing things that does require some really active on-the-ground work. Preserving, that's limited to certain special areas. Enhancing, and sometimes creating. I've been to a bunch of created wetlands. It's really fun to go out with the scientists to their created wetlands because they walk out there and they say, well, see what's happening here, and here's all the functions and values. But this is not really what we planned. We planned X, Y, and Z, and this is what happened instead, because it's really hard to create nature from scratch. But the thing that's neat about the ones that are established is usually they really are having ongoing scientific study of it and making sure that it is achieving something, but it's almost never, and certainly never at the places that I've gone, establishing what they planned on. When they were figuring out how they were going to implement this new rule, they also said, okay, so we're figuring out what people are doing. Let's figure out who's doing what. Permittee responsible. When I'm going out and I'm getting my permit, then I'm told you have to go do this 60% of the time. Banks, about a third of the time. And then this in lieu fee in certain areas of the country is very common because banks aren't available and it's hard to do on-site mitigation. Is about 7% of the time before this new rule came into place. Mitigation banks, they're initiated in advance of the impacts. Sometimes they're started by like the Department of Transportation or somebody on their own. Sometimes there's an entrepreneur that says, I'm going to restore an area, I'm going to do all the things that I have to do with financial assurances, then I'm going to sell, and you can come buy credits from me. Most are sponsored by entrepreneurs. You do have a number. That picture didn't come out as good as it should have been, but you do have a number, including the Kennecott Inland Sea Shorebird Reserve is a mitigation bank here in Utah. So you do have them here, and they are across the country. In lieu fees initiated after the impacts. Most of them are sponsored by governments or nonprofits. As of 2006, there were a number pending. It's really interesting because there was a proposal. In lieu fee wasn't working out as well. There's a proposal to get rid of it, the proposed rule said, and there were so many people, including some people from this area of the country, saying, no, it is an important component, that instead of getting rid of it, they beefed up their requirements to make sure that people were going to be actually mitigating successfully, or to attempt to do that. We have to see as this goes forward. There aren't that many people in the country who've read the entire rule. It's 112 pages of the Federal Register. It's a very long and complex new rule. It's very interesting to read because it's got, and it was very interesting to read in proposal. It's very interesting to read as it's gone forward. It's major themes. It's really trying to say, okay, across the board, we have to have equivalent and effective standards. Across the board, we have to use science to the best available. We have to have things that are going to be, for the regulated community, predictable and efficient. And they really did want to increase public participation, which had been a big concern. There were 1,200 comments. Some of them were the standard email or postcard comments that both sides tend to generate for things like this, but there were a good number of substantive comments, and they actually, having talked with Dave Olson, who works at the Corps, and Palmer Hoof, who works at EPA, who are the primary authors of this, they really spent a lot of time going through that, really attempted to the best of their ability to respond, and that's reflected in their write-up in the preamble to this Federal Register. The new rule requires that compensatory projects have mitigation plans that, and these are all the ones, including the ones that permittees do on their own, that the mitigation banks perform, or these in lieu fees, that there are 12 fundamental new components, that there are clear objectives for the project, that there are clear site selection factors, site protection instruments, that there's a good understanding of the baseline information, both at the impact site and at the site for which you're compensating. There's a good credit determination methodology, detailed and very specific work plan. There's good maintenance plan, really much more specific performance standards. That was one of the things that they had that the National Academy had some real concerns with. Monitoring requirements, long-term management plans, adaptive management plans. Things change over time. Plans to deal with that, and really detailed financial assurances. In lieu fees, which I said have been controversial, there's a really detailed advanced planning requirement in there, and there's a very specific cap on advanced credits.
On your prior slide, there was a recent decision out of the Ninth Circuit, and they upheld a permit issued by the Corps. And one of the challenges to it was that the mitigation measures were, some of them, not all, but some were prospective. In other words, we're going to do 15 things, and then in addition, you're going to submit, you're getting your permit, but you're going to submit a more detailed plan that covers more.
Mm-hmm.
The Ninth Circuit said that was not sufficient defect, given that there were tangible immediate requirements of mitigation. Would this rule change that result?
I believe it would.
I would. That was, and they didn't really mention that in the decision. I thought that, but because it was before this rule became effective.
Right.
Okay.
The ILF also has really substantial financial accounting requirements. It limits it. It didn't before, but now it's really specifically limited to nonprofits and governments. Has ramped up the requirements at very serious administrative and ecological standards that are in place. It has the same public and review team requirements that banks have, which have been very successful since 1995. The other thing that's the direct result of the National Academy of Sciences is there is a directive to take a watershed approach. And it's very clear, there's a lot of work in this, but the thing that's interesting to me when you actually read the rule is lots of areas don't have watershed plans. So when you are actually charged with complying with mitigation requirements for your clients, or figuring out, if you're working for a conservation group, what requirements they should be dealing with, it is going to require some investment of scientific expertise if there's no watershed plan available. So with a watershed plan, it's to be used to the extent appropriate and practicable, and the level of information must be commensurate with the scope and scale of the authorized impacts and functions lost. Without a watershed plan, I don't know why that got bold, should be based on structured consideration of watershed needs and how wetlands and other types of aquatic resources will address those needs. And the district engineers will utilize the considerations specified in another section available information. So I mean, so you're ramping up the requirements on the permit applicants and on the DEs and the district engineers and the project managers to really know specifics and to really assess specifics when there is no watershed plan. Oh, that's less. So it's going to be interesting to watch how this unfolds. There is some level of discretion that's given to the districts, but I predict that this is going to be expensive and time-consuming, and there is no more specific guidance out there yet. As I said, Peggy Strand and the folks from the mitigation banking arena were very big part of the language, of getting the language in the appropriations bill that got this in place. And so there's now is an explicit preference for mitigation bank credits over advance credits for in lieu fee, and that is not surprising. There's also, the hierarchy now goes mitigation banking in lieu fee and then permittee responsible. So it really does switch up the requirements, which originally in the 1990 requirements were on-site, in kind, on the site that you're impacting, to credits from mitigation bank. So this is going to be interesting to see what happens to the mitigation banking industry in the next couple of years, since they're now the preferred methodology. In part, it's going to make sense for the, yes?
Sorry, on that prior slide, the sequencing there, the priority or the preference, what if you have a situation where you have a very obvious on-site in-kind opportunity? You have to go through some lengthy analysis of whether, what the mitigation.
No, I don't think so. I think that you can just set that forth and you can make the project manager and therefore the district engineer understand that. But it's a rebuttable presumption. But I don't think it's in detail. But once again, we're still figuring out how this is going to work on the ground. And once again, we've got these 1,200 people with not as many people in headquarters giving us as the guidance that we would like.
I just had a question about if the proposed development is so much basically build the whole lot and it doesn't have on-site potential for mitigation. Do they have to?
Well, now it's going to mean now that we've got this, the most logical place is to go get a credit from a nearby mitigation bank. However, there are areas of the country or areas of a particular state that may not have available credits. And then you're looking to a good in lieu fee program, which would be a nonprofit or a government doing something that would provide those functions and values or their equivalent. And then you can do, then permittees have done for years offsite. But it's a very, very individualistic approach that's very resource intense for those who are dealing with this. And remember, now when I said that many things proceed, the vast majority of things proceed as general permits, mitigation applies to general permits. And so you say, okay, I'm going to be able to proceed under this general permit, but I still am going to have to offset for my 0.7 acres. And so you're going to then have to do this negotiation. Even if you're getting to skip other parts of the permitting process, you're still going to have to do this negotiation on a very specific level, and you're going to have to meet like these new ecological performance standards.
Which instead of just making the development smaller, or it seems like a lot easier to try to make it smaller.
Yeah, I'm going to get to that in a minute because avoid and minimize is my goal. But anyways, yeah. Well, when I represented the industry, there's a very big tension of you got clients who want to develop because they want to make money, and there's tensions because there are people who need places to live, although the housing market crunch is going to be good for wetlands on some level. So there's objective and verifiable performance measures based on the best available science that can be measured or assessed in a practicable manner. I mean, that's going out and doing a lot of really intense, best available science means that you're going out and doing a lot of literature review, you're really figuring out what's going on. Here's the other problem. And this is related to, see, I could like spend all day talking about wetlands, because we've got the Rapanos decision, we've got the fact that we don't know what's going on with the term navigable waters, as I mentioned earlier, which has just caused people to be pulling out their hair. Is this jurisdictional? Isn't this jurisdictional? The people who are project managers and had been for years, many of them have quit, have taken early retirement, have gone off to be consultants because they're just being driven crazy. So across the country, there are lots of empty slots for project managers, or they're going down the hall and they're saying, whoops, they're saying, Joe, I know you've been in real estate for years, but come on down, we really need a project manager. And Joe, who's a perfectly capable person working in this other part of the Corps of Engineers, comes down and is, poof, a project manager. And suddenly dealing with these really complex permits and suddenly dealing with what's the best available science with respect to this aquatic resource in this particular area. Getting expertise on that is a long, hard, arduous process. And there are many people in the conservation community who are concerned that there's going to be a lot of deference given to studies that are given by more wealthy folks who are able to come in with a lot of science at their back. And there's going to be a lot of time and energy spent trying to figure out with the people who don't come in, the landowners, individual landowners who are just trying to figure out what they're doing, who don't have a lot of resources. It's going to be interesting to watch how this plays out on the ground. This is a great theoretical framework. I am for this in theory because I think that it makes enormous amounts of sense based on all the science that I've read. But how it's actually going to play out and how the power is going to shake out with all these stakeholders that have been playing this game for many years is going to take a couple of years to really understand. There's supposed to be an interagency review team. Most states have them in place because most states have been doing mitigation banking for a number of engineers. They're supposed to be looking at these areas, and the district engineer has to use a consensus-based approach, but then they can't let this interagency team put time frames in jeopardy. So then there's a tension because the district engineer may need to take things back. There's a number of phases that need to be gone over for these distinctive phases. A bank and ILF now have some really specific timelines that they're supposed to meet. And how that plays out in practice in the currently overburdened wetlands regulatory arena is going to be interesting to watch. There's a new, really specific requirement with respect to real estate instruments, permanent protections for the sites, and financial assurances. They're supposed to have a high level of confidence. Are you seeing stuff that you can litigate about right here? What's a high level of confidence that the compensatory mitigation project will be successfully completed? It's going to be, once again, on-the-ground decisions that are going to be really site-specific, that are going to be interesting to watch. And also, I'm lucky enough to be an academic. I probably should put myself as a stakeholder because I'm an academic and get to watch this. You know, watching what's going on here versus in my current home versus my old home when I was born in Massachusetts, how these things are actually playing out. Long-term management plans, funding to cover stewardship tasks is a new requirement coming from the National Research Council report, a very big commitment to recognize the obligation to protect these resources, but back again, protect the biological and other values that Congress has identified for the Clean Water Act. Enhanced public participation. There are requirements that we let people know in a very specific way what's going to be happening, how things are going to be avoided, minimized, and compensated for, letting the public be part of this process. What I haven't had a chance to do yet, which will be interesting to do, is to really look comparatively at some of the public notices and see exactly how much more is being provided about avoidance and minimization. Environmental Law Institute has done some studies of avoid and minimize. It's really hard to figure out if people are doing that well. How do you know when you're avoiding enough? How do you know if something's minimized enough? What's a practicability test that's actually going to be able to be implemented? Compensation is something that's data-driven. Avoid and minimize. Those who studied it say it's really, or tried to study it say it's really hard to study. But there are new requirements, and there are new requirements to get the public involved. So whether or not there'll be more challenges will also be something to watch. They're also, the other thing is that for many years people said, well, people mitigate, they do this project, and then nobody's looking at it 5 years down the road to see how it's working out. There's new requirements with respect to monitoring. Monitoring reports after 5 years are now required. But as I've just gone forward very quickly, there's a lot of issues, just as in this brief conversation, and those of you who do this sense the issues, those of you who this is new can kind of hear as lawyers what's going on with this. When the rule was issued, there was a promise that there were going to be training sessions for employees that were then going to be ratcheted out and training for the general public. That hasn't happened yet. There are no further guidance documents. There's a real dearth there, in part because the Corps and EPA is just busy dealing with a lot of stuff. They're it's going to take a lot of resources to implement these. Where are we going to get them? How's that going to be met? That's a big deal. There's a decentralized, we've got the decentralized nature of the Corps, how that's going to play out, and whether they're going to be effective is something we're going to need to think about. So we're not going to know for a good number of years what the impact of this rule is. We just know that it's big. This connects, I'm just going to briefly tell you about some research I've done recently because it connects to this research that I've done about customer satisfaction. The Corps views people who come in and get permits as customers. They take surveys. You can actually go to the Corps website, see the survey. Not all the districts collect them, but when they do, when I first found out about this, I'm like, wow, I'd like to see what these surveys are. So I sent in and asked for a couple of district surveys. Turns out that a number of districts don't collect them. So then I got them from all around the nation. And when you look at all the districts that collect them, an impressive percentage say the Corps is doing great. The Corps is really doing a good job. That's where the survey is. It varies by district. All the types of Corps permits are processed. And everybody appears to be given the opportunity to provide this. It's a 2-page survey. You rank things on a scale of 1 to 5 on the first page, and then you turn it over and you're allowed to write some text on it. It's not entirely clear who gets this, who is a customer. Technically, it's only sent out to people who go through the permitting process, but the Corps does define their customers more broadly. And when I published this article, when I posted an article last year, there's one district Corps that in order to go on their Corps regulatory website, you have to actually decline the opportunity to fill out a customer service survey, which is fun, because suddenly they wanted everyone who's going to their area to become a customer. But the compiled results, it's really hard to see here, but the compiled results show that the vast majority, like in the Alaska district, the vast majority overall rankings, when 5 is the highest, 40% said 4 and 36% said 5. Sacramento district, one of the districts in Utah, 25% gave a rating of 4 and 57% gave a rating of 5 out of 447 surveys. So you've got a lot of people who are really overall happy with the permitting process as part of the Army Corps of Engineers. I'm not going to sample text comments. Service was exemplary. Everyone I met at the Corps has been very helpful. Excellent service. You guys do a good job. Some people complain about particularly the timing. It's taking too long. But the thing that's interesting about this is going to be seeing, I did this work with data before Rapanos came out. I did this research with data before this new mitigation rule came out, whether these rankings change as a result of that. So we've got these new rules. They add another layer to this already struggling wetlands regulatory program. This says, for those of you who can't see it, we cut through all the red tape, but a new shipment came in this morning. So, any questions or comments?
Did the new rule clarify the relationship between permitting and the NEPA process, which has always been a question?
It tried to a little bit, but once again, no.
Back to the question that Mike posed, is my view, reading through the rule, and I'm just curious whether you have a different
You're one of the people who read the 112 pages. Yay! There aren't that
I
many.
suspect there are a couple of us in here, but the most significant issue for my clients is the notion of with an individual permittee, you have to have concurrence on your mitigation plan in total before, when the permit is issued as part of the conditions. And if you couple that with maybe questions regarding scope of jurisdiction, you could be looking at a significant backlog. Is that the sense that you've been receiving from other parts of the country?
Yes.
To me, that is huge.
Right.
And the watershed issue.
And the watershed approach, which we still don't know how to do. I mean, I think that, I mean, having talked with Dave and Palmer, having talked with the people who really worked on this rule, they really tried to do what the National Academy of Science did and achieve their goals, and make it a better program. But how it's actually going to work is really, I don't know how it's going to work. And there's nobody that I've talked to who's really happy about it either. I mean, the conservation community really believes that there's still, even though there's a lot more requirements, there's still too much weasel words in it, there's still too much discretion given to the districts with respect to what they can do. And in some districts, that's a concern for the regulated community as well, because some districts, it's a problem with the Corps, some districts are very aggressive in the way that they implement the requirements, and they are very specific with requiring things. And so having discretion in the district is sometimes better for the conservation community and sometimes better for the permitting community, depending on what how that district is operating at the time.
And then one more quick question. I know that the guidance letter on monitoring was issued a couple Fridays ago. Do you know if there's any new other RGLs that are planned with respect to implementing this rule?
Yes, they're.
And what are they? Do you know?
I have not. I know that they have a number of things in draft that are working their way around, but they're lost in a lot of other stuff. And now they're getting. I mean, and now they're in the time frame of election year. So I would not look for anything before the end.
This is a little off the subject, but what is your reaction to the Ninth Circuit's decision saying that a JD is not reviewable under the Federal Administrative Procedures Act?
That's in keeping with the history of the program, that a determination whether something's jurisdictional, and that's part of why this administrative appeals process was put in place about a decade ago, was the frustration of once there's a jurisdictional determination, and yes, it's declared jurisdictional, the only way to actually go to court is to thumb your nose in the face and go forward and deal with that. So I think we could amend the law.
Yeah, I mean, one of the problems we have out here is that the Corps, it's not enough to go in there and say, hey, look, I realize this is a marginal water or wetland. We don't know. I'll agree that it's jurisdictional, but they won't even do that because they're worried that they'll get, sued by the...
They have to now. There's a regulatory guidance letter that they have to do that now. They have to accept, they have to do that now. That was exactly true a couple months ago. And there's been a change up in the administration at headquarters, and they have to accept your willingness to say, I'll accept jurisdiction and go forward now.
Yeah, I was going to say that preliminary JD RGL has been helpful in that regard because unless you really feel strongly about the nature and extent of jurisdiction over your property, then you may not want to concede jurisdiction and move forward. But that has, in my experience, that's
being
been
able to just go forward with
helping expedite.
When I was in private practice and representing permitted community, mostly they just wanted to be able to figure out what they needed to do and go forward and do it. And so I was pleased when that came out for all concerned, and hope that it's eliminated some of the backlog.
Does fluoride that they're adding to our drinking water now have anything to do with this?
Not to my knowledge. I can't think of a way that it would connect it. That would be regulated under the Safe Drinking Water Act, which is a entirely different law. So possibly there would be some connection in certain situations, but it's not directly related to this new requirement.
If you're proponents buying into a mitigation bank, is there still the requirement that you characterize the overall watershed and the impact that the wetlands you're taking out are impacting that watershed or the greater watershed?
Yes, I mean, no, if your project manager agrees that the mitigation bank that you're opting into is appropriate for your permit applicant.
So it's pretty specific to who you're dealing with.
That's the problem with all of this, is it really goes down specifically to decisions that individuals make and really site-specific decisions, and it should on some levels, but it's very difficult to do advanced planning without more guidance. And once again, this is one of those things of I can tell you what the rules say, but we still don't know enough about how it's actually going to be implemented on the ground to know whether or not that's going to develop over time as well, and whether or not different districts are going to interpret that differently.
You mentioned the financial surety aspect. Have you seen any creative mechanisms that the Corps has been willing to accept in terms of financial surety, or is it pretty cut and dry from what?
It's been traditional in all the ones that I've looked at. Now, I don't do this, I don't work for permit applicants anymore, and so I don't know about that. But once again, that this is going to come down to, I'm sure that there are specific districts that will allow, as long as they can interpret it the right way, things that other districts won't. So you're going to need to know specifically what's going on in your field office even. I mean, it's not even, I say district, but then there can be really, really different field office differences as well. Thanks, y'all, for spending time with me today, and have a great rest of the afternoon.